Hello and welcome. My name is Bethany Barrese and I'm here with members of Saxe, Doernberger, and Vita's Bad Faith Practice Group. Today we're going to be discussing how auto accidents drove bad faith litigation in 2020. So before we jump into the details, I'd like to just quickly introduce you to our panelists. So I'm going to ask everyone to say a little bit about themselves. Stacy, you're up first.
Hi, I'm Stacy Manobianca and I'm of counsel at SDV.
Hi, my name is Avila. I'm an associate at SDV.
Hi, I'm Amanda Fenelon, and I'm an attorney at Saxe, Doernberger, and Vita, pending bar admission.
And again, my name is Bethany Barrese. I'm a partner at SDV, and here we exclusively represent policyholders in all sorts of insurance coverage issues, basically from the policy all the way to the claim. We've seen it all. And I lead the firm's Bad Faith Practice Group. So when our group came together just to think about what lessons did we learn from bad faith litigation in 2020, we noticed a really interesting trend. Basically, there were a significant number of appellate level decisions that came down in 2020 that all arose out of automobile accidents, hence the title of today's webinar. It makes sense if you think about it a little bit, because auto accidents can result in significant damages. And a lot of the time, if there's an uninsured motorist or an underinsured motorist involved, there's not going to be a lot of insurance coverage to pay for those damages. So not just in auto accidents, but in any type of claim, when you have a claim that has a really significant amount of damages and high exposure to the people who are involved, but there's a limited amount of insurance to cover with, naturally the parties that are involved are going to be under a lot of tension. And everybody's going to start looking for, the other side to make some sort of misstep. The insurer's conduct in particular comes under higher scrutiny in these circumstances. And there's also a lot of litigation that can result when you have high damages and low amounts of coverage. So as policyholders, we think it's really important for us to stay informed on the status of the law and how it's changing over time. So today what we're going to be doing is providing you with some key takeaways and lessons that we learned in 2020 from insurance bad faith cases that deal with failure to settle, unreasonable denial of a claim, and also improper claims handling. So with that, I'll move to the first case on today's agenda. It's Peterson v. Western National. And this is a case where the Minnesota Supreme Court gave new guidance on how to interpret Minnesota's bad faith statute. So with that, I will turn it over to Stacy to fill you in on the details.
Peterson versus Western National Mutual Insurance Company involved just the type of case that Bethany was just discussing. There was a failure to settle, but really an unfair investigation, because ultimately, as I'll explain, Western National never really had come to a decision or denied the claim or paid the claim for Ms. Peterson. So Ms. Peterson purchased an automobile insurance policy from Western National. The policy included underinsured motorist coverage with a policy limit of $250,000. Subsequently, Ms. Peterson was involved in an automobile accident, and she sustained significant whiplash injuries and suffered from chronic migraines that required Botox injections to manage. The at-fault driver only had a policy limit of $50,000. Ms. Peterson conferred with Western National, and they consented to her settlement of the claim against the at-fault driver for $45,000. Thereafter, she filed a claim with Western National for underinsured motorist benefits. She sought the full policy limit of $250,000, and she submitted copies of her medical records and bills to substantiate her claim. But for over a year after she submitted her claim, Western National failed to either pay her benefits or expressly deny the claim. Instead, they continued to make requests for additional information and bills and medical records, and oftentimes they requested documents that they had already been provided by Ms. Peterson. Notwithstanding, she continued to provide the information promptly to Western National to no avail. Ultimately, she filed a lawsuit. Western National defended the lawsuit and hired a neurologist to conduct a medical examination. However, the neurologist chosen by Western National did not specialize in migraines, and he wasn't familiar with the use of Botox to treat migraines. The jury found that his conclusions were therefore unsupported and ultimately awarded Ms. Peterson $1.4 million, which included more than $900,000 for past and future medical expenses. At that time, Western National finally paid its $250,000 policy limit. As permitted by Minnesota law, Ms. Peterson then amended her complaint to seek taxable costs and attorney's fees arising out of Western National's bad faith handling of her claim. The trial court ruled in Ms. Peterson's favor and awarded her $100,000 in taxable costs and $97,940 in attorney's fees. Western National appealed the decision, ultimately all the way up to the Supreme Court, which is what led us here today. So as Bethany stated before, for the first time, the Minnesota Supreme Court analyzed the insurance standard of conduct in this context. The insurance standard of conduct provides for the award of taxable costs to an insured against an insurer when the insured can demonstrate, first, the absence of a reasonable basis for denying the benefits of an insurance policy, and second, that the insurer knew of the lack of reasonable basis for denying the benefits of the insurance policy, or it disregarded the lack of a reasonable basis for denying those benefits. In analyzing the statute, the court clarified that the plaintiff has the burden to establish both of these prongs. With respect to the first prong of the analysis, an objective test is used. In other words, the court will look to see if, or a fact finder will look to see whether a reasonable insurer under the circumstances would not have denied the insured benefits under the policy. In making this determination, the jury or the court should look at two things. First, the level of investigation that a reasonable insurer would undertake and how that reasonable insurer would have evaluated the claims in light of that investigation. And second, whether or not the insured's claim was fairly evaluated. A fair evaluation means that all of the facts and circumstances surrounding the claim were given the appropriate weight when the insurer evaluated the claim for coverage. The second prong of the analysis, however, is determined a little bit differently and requires a subjective standard, which means that the insurance company in this situation, the actual investigation and evaluation recklessly disregarded or remained indifferent to the information that would have allowed it to know that it lacked an objectively reasonable basis for denying the claim. So to clarify and put that in context a little bit, the court here concluded that based on the facts of this claim, no reasonable insurer would have denied the benefits of the insurance policy. And based upon the actions of Western National, that their failure to consider the proofs provided by Ms. Peterson rendered them in reckless indifference to the facts and proofs submitted, and they should have covered the claim. This is significant because policyholders under the statute can obtain extra contractual damages if they're able to establish the prongs of this test. Those extra contractual damages can include pre and post judgment interest, taxable costs, and attorney's fees up to $100,000. In some instances, the statute does allow for the award of punitive damages up to $250,000.
Stacy, let me just jump in here. I think this is one of the reasons why this case is so important, because it's really providing some significant and clear guidance to policyholders on what they need to do in order to prove the bad faith claim. And that's important because, unless you prove and succeed on your statutory bad faith claim, the types of costs and damages that you're mentioning might not otherwise be recoverable if, for example, the policyholder just brought a standard breach of contract claim.
Right, that's exactly right. That's why this case is important, and it was going to be able to guide policyholders going forward in bringing these types of claims.
So speaking of damages that would not be recoverable absent a bad faith claim, let's talk for a little bit about the Whiteside versus Geico case. This is an 11th Circuit case. It also involved really significant damages with a very limited amount of insurance coverage to cover the loss. So Amanda, can you tell us a little bit more about this case?
So this case potentially deals with improper claims handling. In this case, Geico was faced with a demand for a $30,000 policy limit, and it refused to settle the case on behalf of the insured. It insisted that it wouldn't pay above $12,000. So when the insured was sued, she threw away the complaint and she didn't forward it to Geico. She was under the impression that Geico was already handling the case. As a result, a $2.9 million default judgment was entered against the insured, and the insured parties sought to collect the judgment from Geico, which had not been aware of the litigation. So here, the primary issue in this bad faith litigation is because Geico wasn't aware of because Geico would be held liable, whether Geico would be held liable for bad faith for failure to settle the claim when the insured ultimately lost her right to coverage under the policy due to her failure to notify Geico about the lawsuit. So essentially, like, Geico was not aware of the lawsuit, and the issue is whether Geico should be held liable for not properly settling. In the arguments, Geico argued that it would be fundamentally unfair to hold it responsible for the judgment in case that it was not made aware of. But the injured party argued that the Geico had a duty to represent the insured's interests, and it should have paid the $30,000 settlement. Overall, this case will likely result in significant precedent in Georgia bad faith law, and the courts have yet to come to a conclusion, but it's definitely a case to keep an eye out for.
Yeah, when I read this case, I thought that each side presented some pretty compelling arguments, so much so that the 11th Circuit ended up not actually even ruling on the substantive issues, and instead they certified questions to the Georgia Supreme Court to rule on, these issues of bad faith and how the bad faith standard should be applied. Yes. Thanks, Amanda. So let's talk now about Berg versus Nationwide. This is another case that involves some unsettled issues of law, and Andres is going to fill us in on this one.
Thank you, Bethany. So this case comes from the state of Pennsylvania. It involves an auto accident that occurred in 1996. It's quite an old case that ultimately was resolved by the Supreme Court last year. It was a property damage only auto insurance case where it involved a Jeep, and basically the shop or the auto repair shop that the insurance company, in this case Nationwide, had as part of its providers. The shop advised the insurer that the Jeep should be totaled due to its twisted frame, and but the carrier in this case chose to save the $12,500, which was the cost of replacement of the Jeep, and instead opted to repair the vehicle and return it to the insured. So this case at the trial level ended up in an award of $18 million in punitive damages and $3 million in attorney's fees. So you can see that what started as a $12,500 claim for a total loss auto insurance accident or claim ended up in a $21 million award for punitive damages. Basically, at the trial level, the court found that the insurer acted in bad faith, that in reckless disregard of the insured's interest, they opted to save $12,500, chose to repair the car and return it to the insured in an unsafe condition, putting the insured at risk and also the public in general at risk. This decision of the trial level was appealed. So at the appellate level, what happened is the Superior Court in Pennsylvania vacated the trial court's judgment. The appellate level court found that the insurance company did not act in bad faith. They found that the duty under the policy was limited to paying the repairs for the Jeep, nothing more, and that Nationwide had no duty to inspect their shop's repairs for quality. The appellate court also found that there was no evidence supporting a finding that the insurance company vetoed the initial total loss appraisal in order to save money, to save the $12,500. They didn't find evidence that the insurance company forced the repair shop to repair the Jeep, knowing that it could not be restored to its pre-accident condition. And then the appellate court also found that there was no evidence showing knowledge by the carrier that it allowed the repair shop to return the unsafe Jeep to insured. This decision then was taken to the Supreme Court of Pennsylvania, and last year this case was considered by the justices there. Unfortunately, one of the 5 justices had to be recused, so we were left with 2 justices siding with the policyholder and 2 justices siding with the insurance company, which led to deadlock. And this meant that the appellate decision that vacated the $21 million award of punitive damages was not in effect. So at the end, the insurance company was not ordered to pay these bad faith damages. Basically, the 2 justices that sided with the insurance carrier found that the duty of the insurer is not merely to pay for repairs of cars, but also to restore the vehicle to a safe and serviceable condition. an expansive duty under auto policies. They would have found. They would also have found that the insurer manipulated the repair shop, putting the insured at risk. They would have ruled that the insurer engaged in a litigation strategy designed to spend as much money as possible, far in excess of the original claim of $12,500, and that bad faith also derives from the insurance attitude in litigation of aggressively defending small claims up to the Supreme Court, sending a message to the general public. The other justices that sided with the insurance company would have found that there was a colorable claim of judicial bias at the trial level, and that there was no evidence of bad faith. So given the 2-2 opinions at the Supreme Court level, they couldn't reach an agreement, and the appellate decision that vacated the trial court's order of punitive damages was still vacated. So
Andres, I think it's interesting to point out here that between the coverage litigation at the trial level and then the mid-level appeal and then the highest court appeal, this case effectively was resolved by a draw 24 years after the accident occurred, which if you think about it, that's an incredibly long time for a policyholder to have insurance coverage issues hanging over their head like that.
Absolutely agree with you, 24 years and to end up in a deadlock, which actually brings them back to what happened at the appellate level. But I think the lesson of this case is that bad faith litigation can result in significant award to policyholders. Your claim could be $12,500, but if the insurance company acts in bad faith, it could end up in awards of $21 million, like in this case. It depends obviously on the facts. But this remarks the importance of obtaining coverage counsel with the right background to assess your bad faith claim.
Thanks, Andres. So I'm going to wrap up today's discussion by talking about Aldana versus Progressive. This is an 11th Circuit case. It also involves nearly a decade of litigation so far, and probably with more to come in the future. But we'll start off in December 2013. This is the time that the accident occurred. It incurred a driver named Yolanda Aldana. She was in the car with her 4 children, and she was stopped at a red light, and she was rear-ended by another driver named Nathan Piles. And then the Aldana's car rear-ended the car in front of them. So we're talking about a 3-car accident here. And sadly, that accident resulted in some really serious and very permanent and disabling injuries, including injuries to the Aldana's young children. There were 4 children in the car at the time. So Mr. Piles, the driver who initiated the rear-ending, he was insured by Progressive, and his policy had a limit of $500,000. So Progressive came in, they did their investigation, and they determined that Mr. Piles was entirely at fault for the accident. So they offered to settle the case for the full policy limits, but there were some conditions. The first condition was that the claimants had to release Mr. Piles from any personal liability beyond the policy limits. And the second condition was that the claimants were going to have to figure out how to apportion that $500,000 worth of policy limits amongst all of them. And remember that there were 2 cars full of victims. There was the Aldana's, and then there were also injuries, although less serious ones, in the car in front of them. So the Aldana's attorney heard the settlement offer, and they said, that's going to be virtually impossible because between these 2 cars worth of people that were hit, you've got too many injured people and too many really serious injuries for them to apportion just $500,000 amongst themselves, especially because it involved 2 families that weren't related to each other. So the attorney asked for some financial affidavits to determine whether Mr. Piles was going to pay for the amounts of injuries that exceeded the policy limits. So Progressive did request the financial affidavits from Mr. Piles, but they didn't really give him advice about what he was facing as far as potential exposure for these, again, very serious bodily injuries in excess of the policy limits of $500,000. So ultimately, of course, the case didn't settle. And the Aldana's filed a lawsuit against Mr. Piles, and the jury decided that the Aldana's were entitled to $52 million in damages. So that's pretty well above the $500,000 that they were offered by Progressive. So what Mr. Piles did was he assigned all of his rights against Progressive to the Aldana's, and the Aldana's then sued Progressive for bad faith. And during the coverage litigation, Progressive essentially argued that it didn't act in bad faith because there was never going to be any reasonable opportunity to settle this case for the $500,000 that they had. And the Aldana's responded that what Progressive should have done was offered their family the full policy limits as opposed to everyone who was injured between the two cars, because the Aldanas suffered the more serious injuries. And they said, even though they were awarded $52 million at trial, they would have taken that $500,000 and they would have released Mr. Piles from further liability. So therefore, there was an opportunity for Progressive to settle the case and protect its insured, Mr. Piles, from liability above the policy limits. The Aldanas also retained an expert, and the expert looked at Progressive's claims handling, and they identified a number of failures on Progressive's part. They said that Progressive should have independently assessed the value of each person's claim. Progressive should have told Mr. Piles about that information and should have made recommendations to Mr. Piles about how he could implement strategies to avoid liability above the policy limits. So at the trial court level, the court actually sided with Progressive. They agreed with their argument that there was no reasonable opportunity to settle this case, and they awarded summary judgment to Progressive. But then on appeal, the 11th Circuit overturned. And what the 11th Circuit said, which I think is important for all policyholders to know, is that the insurer's obligation to act in good faith includes the obligation to advise the insured of settlement opportunities, the obligation to advise as to the probable outcome of the case, to warn the insured if there's going to be a possible excess judgment, and to tell the insured about any steps that it can take to avoid that excess judgment. And in particular, and Florida law was applied here, in particular, where there are multiple claims arising from a single incident, as there were here. So the 11th Circuit ended up holding that while Progressive did act reasonably in making the initial offer to settle the case for full policy limits, there was sufficient evidence to find that Progressive didn't keep up with its duty of good faith from there on as the negotiations continued and as they continued to work with the Piles on resolving the case. So the trial court's decision was vacated. And at this point, the case has been remanded for a jury to decide whether or not Progressive acted in good faith. So this is another case that SDV is going to be monitoring because we think it will have some pretty significant implications on the scope of bad faith coverage in Florida and beyond. So that concludes our discussion for today. If you're interested in learning more, you can contact any of us directly, or you can visit sdvlaw.com. All you have to do is look for bad faith under the services and industries tab of our website. You'll find there a link to a summary of each of the cases that we talked about today and a lot of additional helpful resources on bad faith. So thank you so much for joining us and have a great day.